Hi, Bill Henshaw here again on my Win in Court YouTube channel, and I'm very excited. I've just gotten a local case here in California where I am, and it may be a big time deal because it involves a lot of things. Now, this one may make some news, and you may read about this not only in California, but across the nation as well, because the big headline potentially could be crazed constitutional kook slash white supremacist defends black defendant. When have you ever heard that happening? Well, you may be on the cusp here of getting exactly that because I've talked to this guy's mom. He's in jail. I can't talk to him right now. And we've struck up a very good relationship in a very short amount of time. It's great to have, a lot of trust going both ways with people. That's the best part of what I do, is that amount of trust, because we're all in here. We've got to have each other's back, and you can trust me out there. Those of you who acquire my materials, I will have your back. So you won't have to worry about that. I follow up. In any case, the important part here is that this case is an opportunity. I've already sent my friend some of my documents, in fact, all of them actually, and I said, listen, send these 3 or 4, take them down hard copies to your son's quote-unquote attorney and ask him to file the documents and set a motion hearing. That ain't gonna happen. And yet we have a demand for a bill of particulars that the Constitution mandates you have a right to use that and learn, among other things, by the way, the nature and cause of the accusation. That's the jurisdiction and venue of the trial court. The identity of the elements of the crimes charged, and sometimes that's not obvious. For example, most of you out there would know that you're not a quote-unquote person required to have a driver's license, and or you're not a taxpayer required to pay taxes either. Bill of Particulars is the way we get at this stuff, not discovery. That's a general appearance, and you can't do that. But the Bill of Particulars is what it does. And the key part with the BOP is they have to identify the injured party. Whoa, injured party, and there isn't one in these statutory crimes. And if you don't have one of those, guess what? You can't invoke your right to confrontation and cross-examination. That's a right recognized across the board, left, right, you name it. That right has to be there. If you can't do that, you can't put on a case. Why not go ahead and get the conviction, quote unquote, aka a directed verdict of guilt, and get it over with? Damn. So we have that. We have a motion to dismiss. And those of you that have followed my videos might be surprised to hear me say that, because I up until recently I don't do motions. This one, however, is a non-statutory motion, even though in California we have a section under the Code of Civil Procedure 41810 that permits it. I don't use it, and 41810 says this is a special appearance. The hell with it. We do a non-statutory motion invoking the concurrent jurisdiction of a federal circuit court. And now we can bring all our constitutional issues into this court. And those of you listening to this video, check out Article 6, Section 2 of the Constitution. What does it say? That the judges are bound by this Constitution. Doesn't matter what court you're in. If we raise the issues, and especially if we have the status to do it, they're bound by the Constitution. Doesn't matter whether it's a traffic court, justice court, administrative court. Doesn't matter. You raise these issues, that converts the court into Article 3. That's exactly what it is that we need. So I said, give him that. I said to my friend, also give him the brief on the 14th Amendment, which is a dead bang killer. And it isn't that long a brief. I got that one done, I think, in 19 pages. But you read that, you find out that the ratification of that amendment violated all 6 articles of the Constitution. That's a grand slam, people. You can't get any worse than that. But the attorney isn't going to file it. He either isn't going to understand the issues, which is bad enough, or will pretend not to understand them. I think that may happen more often than you realize. It's hard to quantify. But the motivation to do that is that if you file documents like this, the net effect sooner or later is going to be to break what I call the malevolent, malignant monopoly on the practice of law by the State Bar Association. Once we're able to do that, that's going to end a lot of woes that we have and get these damn lawyers out of there and get us in there when we're educated, know our rights, and can go into court and invoke them properly. That's what we really need to do. So this case has a lot of exciting elements here. And if we have a hearing, this is a recognized hearing, an orthodox, hearing that they recognize in their system. And now we're going to have my friend, testifying that she tried to get these documents to her son's attorney and he wouldn't take them. And I'm now going to follow up with expert witness testimony that could take a day or two about what's going on in the last 4 decades, and I can back all of it up with documented, relevant, admissible evidence. A jury will see all of it. So this hearing, if all goes well, might be the end of the case. Because there's enough trouble as it is. If they have this all on the record, now it goes to the Court of Appeals, and guess what? These issues are now there. So they can't now say, like the California Constitution here tells them to do, to find everything to be harmless errors. Conviction affirmed. See you later. Out of here. With these issues in there, and if they're bound by this Constitution, they have to rule on them. What that means is sooner or later, probably sooner, we get the case to the 905 and say, at last, here we are. It's about damn time you do your job and clear the air here. Tell the American people the truth. Exactly like what we've done in the papers we filed in this court. That happens. One case. One. It breaks it wide open. That's how much power we have. That's a binding precedent from Portland, Maine to Portland, Oregon. And there isn't a damn thing they can do about it, short of getting an amendment, which on another video you're going to learn there's no way in hell they can do that. And haven't been able to do it in 150 years. So this is why I'm so excited about this case. We'll have updates on this. And we may even have videos sooner than usual if things break as I'm anticipating they do. I don't know when the hearing on the motion might be held. In theory, a couple of 3 weeks, but right at the moment, I don't know. They have to stop all the other proceedings, though, with this motion. They can't proceed forward without an attorney. So they think. So this is a really interesting case, and I'm dead bang excited about it. And I will get back to you with updates, especially those of you that subscribe to me on my YouTube channel. And if you want information on my materials, send me an email at uwinincourt@gmail.com. And I'll provide email updates and information on obtaining my materials, and you can do the same thing in your case that we're doing in this one, and it's a lot easier than you think. Hi, I just want to remind all the listeners out there to like my videos and subscribe, and check my earlier videos on the motion to dismiss, the Bill of Particulars, and the 14th Amendment. You'll find a lot of valuable information there. And feel free to check in with me, email anytime. I respond to most of them. And get my package. You're going to learn more than you can imagine in a short amount of time. Thank you.